All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So, Phil, you mentioned that our viewers, if they haven't watched yet, should go back and watch Jim Plunkett and my discussion from last week on the Supreme Court's decision in Looper Bright, which, of course, was the decision that overturned Chevron deference, the 40-year standard that had been put in place previously by the Supreme Court, basically telling the courts that they owe deference to the federal administrative agencies when interpreting laws. In this case, for our purposes, the federal employment laws, the FLSA, the ADA, Title VII, ADEA, National Labor Relations Act, et cetera, et cetera, et cetera. And so, of course, with that decision from just a few weeks ago, there are cases that are already in the pipeline. And there's one such case right now that's pending in the Seventh Circuit, which has jurisdiction over our members over in Illinois and Indiana. And the case that's pending over there is a case against Amazon. And Amazon argued just yesterday that the Seventh Circuit, quote unquote, owes no deference, none, zero, to the National Labor Relations Board's determinations about violations of federal labor law. Amazon, of course, is referencing the overturning of the Chevron decision. And in this case, the NLRB had issued a complaint against Amazon and ruled against Amazon regarding Amazon's off-duty access rule. And what Amazon is now arguing to the Seventh Circuit is that the Seventh Circuit owes no deference to the board's legal conclusions. And what I've been saying all along, and this is kind of why.
So Bert, am I understanding then that what you're saying is that the court isn't evaluating the decision that the EOC made,
the NLRB.
I mean, NLRB, the court needs to look at this completely on its own and take their position out of it.
Take the NLRB's position out. Yeah. So we call that
significant. That is significant.
Yeah. And that's what the Supreme Court essentially did when it ended Chevron deference. And now Amazon is making this argument to the Seventh Circuit. And as I've said all along, and the reason why I think that Chevron was going to get overturned is that basically Amazon made the argument in this case that the NLRB's shifting precedent when the political parties change, it makes it increasingly clear that the board behaves less as a neutral dispenser of specialized labor relations expertise and more as a politically motivated body whose legal conclusions swing wildly back and forth based on the political party to which a majority of its appointed members belong. And that's exactly what I've been saying all along, is that, it just creates unpredictability for business. And on some level, you've heard me say it a dozen times, business almost, not completely, but almost doesn't care what the law is. We just want to know what it is, and we want it to stop changing every 4 to 8 years. And I think that this is a really significant case that we need to keep our eye on, because it's going to be one of the first decisions out there interpreting Looper Bright, and whether the court is going to give any sort of deference to the NLRB's position, or whether it's going to review the case, what we call in legal terms de novo, which means fresh from the beginning, and make its own decision.
Out those fancy words. Look at you.
Exactly.
Again. Thank you for keeping us sharp, Bert. All right.
Of course. All right.
What else do you have?
Yeah, the other one, I've got two things that I want to touch on that are tied together, Phil, and another thing that I've talked about often on the program, and we've confronted the issue head on, because it is an issue that our clients and our members face all the time. And we want to make sure that they are doing things correctly, and they're not wildly venturing into areas that could get them into trouble. And one of those areas is DE&I, diversity, equity, inclusion. And repeatedly on the show, I've encouraged people to make sure that their companies are not going about this haphazardly. That if they do, that can create potential liability exposure when companies start wading into this area for, maybe improper reasons. And so a case I want to talk about is a case that was filed last week against one of the large law firms here in St. Louis that has operations throughout the country, some overseas offices, and the law firm is Armstrong Teasdale. And they are being sued by their former diversity leader for race and sex discrimination. And she's accusing the firm of a pattern of discriminatory behavior, basically saying that the firm withheld leadership training, a facilities badge, and investment in DE&I programs. She also accused firm members of subjecting her to a hostile work environment. Now, I want to say, again, I'm not making any statement with respect to the merits of the claim, but the allegations themselves are basically that Armstrong Teasdale put in place a DE&I program and then didn't support the DE&I program properly. And so they're being sued. Now, I will tell you, no love lost for me on this one, because the plaintiff's attorney who's suing them is one of my least favorite attorneys I've ever encountered in the practice of law. He practices over in Kansas City. I'm not going to mention him by name, but he has recently been the subject of some scathing court opinions against him personally for his conduct, or I should say his misconduct in litigating cases. So from that perspective, I take the complaint itself with a grain of salt, because this guy has quite a reputation. So this also ties in, though, Phil, with another lawsuit that was filed in Connecticut federal court last week against another company, where this individual is a white employee and he's suing his former employer. He's a fired plant manager, and he's suing over the diversity, equity, and inclusion push that he supported. He cited his own multiracial family while discussing with colleagues his beliefs about the importance of diversity, equity, and inclusion. And Phil, I'm going to give you one guess. When he brought that up, what did the district manager say to him? This is an unfair question for you, but I'll still throw it out there.
I mean, ask Monique, ask producer Nickel. You always put me on the spot. Go ahead, just give us the answer. We're on the clock here. Yeah.
All right. The district manager said, "We do not talk about race here." So that was the response. So when this individual brought up the importance of DE&I in the workplace, and the district manager said, "We do not talk about race here," that's not the proper way to handle a discussion like that. And so again, I just raised these two cases from the standpoint that people really do need to be cognizant of venturing down this road. And if they do venture down this road, making sure that they properly support the effort. They're not doing it just for appearance sake, and that they really are committed to a truly diverse, equitable, and inclusive environment. That includes DE&I for everyone, not just some people, but for everyone.
I think that's where people kind of get it wrong by the guidance that you have brought to light with us. Is that you're real careful. You have to be really careful what we're doing here. Not that we're not in favor of treating everyone fair and equal, but sometimes the intention doesn't deliver that outcome, and that's what we have to be careful of, which is really kind of all of a funny position, isn't it? You're trying to get it right. You're making investment. You're hiring people, and then you create yourself a different problem. That's exactly not exactly at all what we want to do.
Yep.
All right, great, Bert.
That's it.
Anything else?
No, let's move on, Phil.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.